Thank you so much for that wonderful welcome and for having us all here today. It is such an honor to speak to you on this critical topic, and I really appreciate all of the introductions and the welcome, and to be here with my esteemed panelists. We have a wonderful lineup, and it's my honor to moderate this discussion. But before we get into that discussion, I want to set the stage for what we will be talking about today to provide a little bit of background. And I will start by saying I also am grateful for the conference organizers and the thought that has been put into this agenda. I really think it comes together really well into what we'll be talking about here today. Looking back early yesterday morning, Chief Justice Gildea spoke about how we can shape a new post-pandemic era and the need to rethink and redesign how we deliver justice. And so that kicked us off right away yesterday morning along this theme of transformative paths to justice. And Alicia Bannon spoke about the way that our courts are under pressure. And she encouraged us to resist the natural temptation to do things the way we have always done them. And that's exactly what our panel is about today. As has been shared, the pandemic has had lasting implications for our justice system. And in the face of great challenge, innovation has abounded, and you have all seen that. You have all experienced that, both the positives and the challenges of that. But before we talk about that innovation, I want to spend just a few minutes about what we have learned over the last few years about the extent to which people are or are not able to resolve the justice problems in our country, and able to do that in a fair, accessible, and equitable way. Because I think it really sets the stage for why this innovation is so critical and hopefully inspires you all to go back and continue this innovation in your own courts. So IALS, the Institute for the Advancement of the American Legal System, it's a mouthful, and I wanted to just say one thing, just a little context for what the organization I lead is doing. So we're a small but mighty organization, a research-based group located at the University of Denver. We're about 15 people, and we partner and work around the country with others to improve the justice system. That's our goal. And we really are focused on research, bringing evidence-based approaches to improvement. And in addition to research, then partnering and collaborating with others, with diverse people around the table to identify the issues and then focus on solutions. So today is a perfect example. It's a microcosm of what we do at IALS. And it's wonderful to have this conversation with all of you. And so I'm going to start with research, just a few highlights, both from IALS research as well as others, to set the stage for our discussion. And in 2020, IALS partnered with HIL, the Hague Institute for Innovation of Law. It's a similar think tank that works at an international level that's located in The Hague. And we partnered with them to bring to the United States a justice needs study that they had conducted in many countries around the country. And we brought that to the United States, asking over 10,000 people about their experiences on the ground. Our key question was, what did the experiences of people on the ground tell us about their paths to justice? And what do we need to ensure justice for all in our country? Make sure this is moving. All right, thank you. One of the main ways that we learn about justice in the United States, particularly everyone in this room, is to look at court data. And I started my morning thinking about court data in a session, and I'm committed to thinking about court data. I think court data is so important. And we often look at court data at IALS. But in this moment, for this project, we launched a study where we didn't look at court data, but we actually talked to people on the ground and asked them about their experiences. Because it's so essential to understand people's experiences and their own demands for services. So it's not limited to just their experiences within the court, but how are they navigating their justice problems in their daily lives? And so that was the core of this study. And if we know what journeys people take in their attempts to solve a legal problem, then we can know how to design a better, more responsive justice system to those needs. So we purposefully asked a very broad group of people with a variety of backgrounds and income levels about their experiences so we could understand the full scope of the access to justice gap in the United States. And we ask the questions, what are the justice needs in people's daily lives? How do people deal with legal problems? And what is working and what isn't in addressing the justice gap? So I'm going to really skate at a high level across the results of this study so that we can get to our conversation. But for context, the access to justice crisis cuts across the social spectrum. 66% of people had experienced one or more legal problems in the 4 years prior to this survey. We found that no one age, income, or racial or ethnic group is unaffected by the justice crisis in our country. And you see that in your courts every day. The takeaway for me is that this is a vast problem in the United States. And when you have such a vast problem, we need innovative and scalable solutions to address it. And we need many, many different solutions. In addition, just as importantly, a key takeaway is that the effects of the justice crisis are not equally distributed. The nature, seriousness, and resolution rates of the problems that Americans experience are shaped in very meaningful ways by their income, their gender, their race and ethnicity, their age, and their living environment. When we look at that justice crisis through that lens, we see that people are experiencing different constellations of problems, different experiences, and different outcomes based on all of these identifying characteristics. So when we're developing problems, we need to reckon with that fact and understand it and have research to provide insight into how we can be sure to guarantee equal access to justice for all. I'll also highlight a statistic that's not on this slide. The World Justice Project's Rule of Law Index for 2022 ranked the US 115th out of 140 for whether people can access and afford civil justice. So we're close to the bottom in that category. And even worse, we rank 121 out of 140 for the extent to which civil justice is free of discrimination. So we have a lot of work to do. I also highlight the most recent Legal Services Corporation Justice Gap study that was just released in 2022. Low-income Americans did not get any or enough legal help for 92% of their substantial civil legal problems. And that percentage goes down to 86% for people between 125 and 400% of the federal poverty level. So it does not drop immediately above that line. In addition, we have to recognize the impact on people's lives of these justice problems and this justice gap. So 44% of people, nearly half of all people, who experience a legal problem experience negative consequences as a result of that problem. They experience negative emotions, negative impacts on their mental health, loss of money, loss of time, and negative impact on their financial well-being. And that impact flows from them to their families, to their businesses, to their communities. Just a few more highlights here. Approximately 1/3 of those problems are unresolved. So not only do people have these problems in their lives, but they go unresolved, 1/3 of them. And those are the problems that are the most serious and most impactful, that are most likely to be unresolved. In addition to those negative consequences that I've already shared, we focus in then on what are those key problems. And this study did highlight problems like family problems, domestic violence, problems with the police, as the problems that we really need to identify and focus in on that are the most serious and most impactful for people. And our hope was that we would have a perfect answer from this research, and what we found is there is no single intervention, no single silver bullet that will fix this problem. We actually found that it's when there are many solutions, many interventions, that is what can really make a difference. We also found that there's no dominant path to justice. So we have historically thought of justice and resolving legal problems as first, you know you have a legal problem, you find an attorney, and you go to court, and you resolve that legal problem. And what we found is many people do not understand that they have a legal problem. They don't always go to a lawyer. They can't necessarily afford a lawyer. They might not want to go to a lawyer. They might not have access to a lawyer in their community. They go many different places In addition to lawyers, they go online for help. They go to their communities, they go to their families, they go to mental health providers, their doctors, their insurance companies, their faith leaders for solutions. And again, as I said, they go online. So it's critical for our courts to be online. And then the last, just few statistics I will share is going to public trust and confidence. In the face of all these serious justice problems, people are struggling with their trust in institutions, and we heard that yesterday as well in the presentations. That the trust in state courts is the most trusted, but that trust is declining. And we see this intersection in the curve, that Americans are questioning whether courts deliver equal justice for all, and that's reflective of their experiences from our research. So key here today are the questions of what are the key issues, what works, and how can we innovate current paths to justice and scale solutions? Because we need many different paths to justice, and we need to scale those to be able to solve this crisis. The stark reality is that we must transform how we deliver justice in our country to be able to meet this need, to meet this gap. But as has been talked about over the last day and a half, is that we are in an exciting moment where we can look around the country and see that transformation is really happening. It's happening on the ground because the last few years have been a real catalyst for change. So today I am joined by my wonderful panelists here who all have experience in terms of innovations on the ground and insights into what they are seeing themselves. So I'm going to join our panelists here and launch into a series of questions to learn more about their experiences here in terms of what are the key issues and what works. And I will note, as we go through, we have a couple of slides that show some background here, and these are resources. They're in your materials as well. I hate to talk while I'm pulling this. There we go. I'm going to take this with me. So these resources, I really encourage you to take a look at the resources that are on your app. There's a lot of resources like our study, the Justice Gap Study, but also a number of different materials from the Conference of Chief Justices and COSCA that can be a real source of innovation in addition to what we talk about here today. All right. So I'm going to launch us off, and my first question for the panel is, what have we observed and learned over the last few years about the paths to justice in the United States? What have been the key issues from your experience? And I'm just going to go in alphabetical order. So, Catherine, starting with you.
The plight of the last name that begins with A. Welcome, everybody, and thank you, Brittany and colleagues. This is such a thrill to be here. I think, the last few years have just been extraordinary. I've spent my career working on pro se issues, so I'm going to say the last 20 years have been extraordinary with things that started right here in Arizona, and then Minnesota was also an early pro se innovator. But currently, I think three big things that we need that I think about, and one is remote, which I know you've been talking about a lot, the integration of remote or the use of remote technology in courts. I think the question now is how do we integrate it? I spent 20 years in Alaska, so I was doing remote back in 2001, and I'm here to answer the question that I recently, just yesterday, I was reading an interview with a judge from a jurisdiction who said, okay, so I have Zoom and I can do Zoom, but I can't get Zoom and in-person happening together in my courtroom. I can't do remote and in-person. They just haven't figured out how. I'm just going to say from Alaska, yes, you can. You can do it. It's just a matter of figuring out your systems, and you will be able to do that. And I think figuring that integration out, so we're optimizing not just the customer experience, but also the court's experience, both from the administrative standpoints as well as the judicial standpoints, trying to get the best evidence possible so judges can make decisions on the merits, right? The goal that we're all seeking. The second area is investment in our sector, private sector investment. And specifically, I'm going to talk about the investment that the Public Welfare Foundation made about 10 years ago in this sector. Mary McClimate, who was president of the Public Welfare Foundation, decided to invest a whole lot of money in civil legal aid. And she made strategic investments in NLADA, in the Self-Represented Litigation Network, which is what I lead, and Voices for Civil Justice. But she also invested a lot in commissions, access to justice commissions. And the muscle that was built, the infrastructure that was built with the development of those commissions and the Self-Represented Litigation Network and Voices, that when the pandemic hit, we actually had relationships and infrastructure in place to support you all. Some of you might have participated in SRLN's twice weekly calls in those first weeks, sharing information of how to problem solve and just on the ground. Commissions that have been working on the Justice for All project, while they might have not been able to complete their Justice for All project, what they did have is relationships with the community and all sorts of different actors so that they could come together. And then as we saw the eviction diversion money come in, they had relationships and know-how of how to talk to executive branch actors in a new way in order to get that money in place to lighten the load and streamline what was going on in your courts. And so that external private investment in our sector to build infrastructure that supports the work that the judicial branch, specifically you all, do is critical. And I'll just kind of put a little underline under this as you all go back to your communities, because what we're seeing from national foundations right now is that they typically have funding horizons and they're reaching the end of them. So we're having a really hard time getting national foundations in the civil justice space. As somebody who works on that problem a lot, I'm just going to ask all of you to be great champions, and if volunteer if you have testimonials or stories of how having that infrastructure in place when the pandemic hit, of having relationships, if it was helpful, reach out to me so that we can make the case to private investment of why we need to build this infrastructure outside of the court's proper business in order to support the court doing its proper business in the best way possible. And then the third thing I just want to mention, which is a sort of a new players in the field, are justice tech entrepreneurs. I know many of you are in jurisdictions where you might have these sort of scrappy little justice tech entrepreneurs who are saying, I'm going to create an app to do this or that, and you might be pretty skeptical of them. They don't have big operations or stability that your legacy vendors have. But what they're doing, they're typically led by people that have experience in the system. So the design is exceptional. It's usually really good and solves the problem it's targeting to solve. However, they aren't big operations yet. But partnering with you all, I think learning from them, learning how that sector and the promise for that can improve not only the product that you get from your legacy vendors, but can develop new and innovative ideas of how to serve the public, because they really are facing, looking at that question of serving the public.
Great, thank you. I'm going to turn it over to you, Edwin.
Well. From where I sit, as you showed on one of the previous slides with respect to the 2022 survey, as to the trust or public trust and confidence that the public has in our systems, we know that it's waning. And it's waning because, in my opinion, and based upon my experience, the vast majority of the people who enter our court facilities, who are litigants, who are participants in various judicial processes, don't necessarily believe that the systems that are in place were created for them. The problem with that is that, that's partially true. But on the other side, in the name of efficiency, there are many things that we do, or I would say I used to do, in courts that were put in place to benefit and support the sort of transactional nature of jurisprudence. But we're not doing a good job at communicating to the general public or to other community-based organizations what we're doing and how what we're doing will benefit them or is in place to support them. There are things that have occurred in this country. Certainly, Mr. Shorba touched on the tragic events in 2020, which quite frankly led to the creation of the very position that I now hold. We, and when I say we, I'm including myself, we collectively have to sort of step out of the shadows and engage people where they are. It's not sufficient to say that we are fair, we are just, we understand you. We have to show people, and we have to meet people where they are in order for them to receive that information. I'll give you an example. Most judges sort of hide, and I don't mean this negatively, but they're sort of behind the veil or behind the curtain, right? The average person, even many people inside of a courthouse, does not have access, direct access to a judge, right? If they do see the judge, it'll either be in passing or when they're before them inside of a courtroom. And so there is this natural resistance to want to directly engage with the very people that we're rendering service to. And so it is incumbent upon us as court administrators and managers and judges to reach out into the community to say, here's what we're doing, here's what we are doing. Is it enough? And if it's not enough, what can we do better? Now, typically what happens? We come together, we're sort of like-minded people. We operate in the legal or the court space, so we understand how the game is played. When we have panels and we have discussions and we have meetings and we have this dialogue, the people who are often missing are the very people that we serve. I asked a question several weeks ago in a particular state. The judiciary was about to embark upon some level of work with community and public engagement. And I said, have you invited the people from your transit authority? And they were like, who, the general counsel? I said, no. Whoever's in charge or, someone operational. Why? Because quite frankly, many people who utilize public transit services are the same people who we're reaching out to, especially those who may not necessarily have the financial resources to hire lawyers of their own choosing. I said, well, what about did you reach out to anyone who represents the food pantry network in your community? Food pantry network? No. Why? Well, because these are the very people who have direct access to the people who are I hate to say this, but the least of these, who don't have the means that we have. And what I believe needs to occur is sort of a recognition of who's at the table and why. Why are they there? If it's the same people that have been there for the past 100 years, then you need to consider not necessarily removing them from the table because their input is extremely important and necessary. However, you may need to expand the table and add people to it who traditionally are not involved in the discussions that take place. In order to have necessary transformation, you have to have people's input. And it cannot be an echo chamber of those people who already know how the system works.
Excellent, thank you. Right to you, Marcus.
Well, thank you, Brittany, and good afternoon, everyone. I want to thank the NACOM conference planners for this kind of a session. I think it's just so timely. I'm maybe slow here. I'm still absorbing the pandemic, okay? And I would agree with Mr. Shorba, certainly transformational change. At the same time, I think it's really an inflection point, and I'm not so sure that some of the changes may kind of slide away. We may kind of fall back into old ways. Some of you have that same sense? And so I think that's part of our leadership role, to be really vigilant. So we'll talk a little bit about the electronic remote hearings and digital signatures and everything it takes to provide those kind of remote services. But I'm also picking up real concerns with the workforce. I don't know about you folks, but something happened, okay, with our staff. They expect to work remotely. They would want much more meaning in their work, I think. And so I think as leaders here, it's kind of a proposition where we need to engage these staff. We really need to sit down and put everything on the table. My sense is to be very candid about this. And what is it going to take to maintain the staff? And there's all kinds of work on organizational development, but this is just such a critical time, I think. And remember, too, some of our staff lost family members and whatnot. And so we're maybe celebrating all these gains, but at the same time, it's tough. And I'm picking up a little bit of, I guess, pandemic fatigue. Some of our clerks of court and administrators, they've just said, we can't take on one more project. Come on, we've seen so much change. So I put that out there not to be a downer on this, but just to say when we go back to our courts, I think maybe it's a matter of trying to prioritize some of the work we do, to maybe even have some active discussions with our bench and with the folks we work with to kind of figure out what really can we expect to get done, let's say this next year, to preserve the changes. Now, Brittany mentioned to you resources. And I don't know if it shows here, but I wanted to really commend this report here, Pandemic Era Procedural Improvements that Courts Should Adopt Permanently. Okay, have you all seen this? I don't know how the center put this together, National Center, September this past year, but it's an incredible inventory of all those tools and resources. And I love how they put this together. It's through the procedural justice framework, right? And so they're saying it's not just technology for the sake of a technology project, but actually we provide better access to the customers that we serve through a lot of these remote services. And I was just looking at some data, I guess, in preparation. So in Arizona, we handle a huge number of eviction cases. I saw it made the front page of the paper again a couple days ago, the volume there in the justice courts. But during the pandemic, as they made that transition to remote hearings, we achieved about a 25% increase in the appearance rate. Okay, so that's procedural justice, where these folks had their day in court, might not necessarily change the outcome of the case, but they had their day before the judge. They were also able to visit with the attorneys and whatnot. And so that's huge. And that's another one of those I think we would want to preserve. And Brittany, I could share some work we're doing maybe with unrepresented litigants, but maybe we'll come back to that just to kind of keep things moving here. Thank you.
That sounds great. Well, it's a perfect segue here. I have already shifted our slide in terms of moving to solutions then. What are we seeing on the ground that is actually making justice more equitable, accessible, thinking not just within our courts, but what are upstream solutions? So what are examples that you are all seeing around the country? So Catherine, back to you.
Yeah, so I'm going to kick off with geospatial data. So that green rectangle on your thing, that's my rectangle. and follow on with something Marco was talking about is we have so much change going on and the change fatigue, right? And just so much really heavy, overwhelming things. So, and I think one of the themes was we wanted to give you resources and possibility. I mean, the comments of we now have people around the table that we didn't have before. And geospatial data is something that allows us to see in a very concrete way what is going on. One of my kids, when she was in fourth grade, it was kind of one of these wild fourth grade classes, and the teacher every day when you picked up the kids, the teacher just looked like that was it. She was done. And she was trying to figure out, she was an experienced teacher trying to figure out what was going on. And so she did this little experiment for herself where she had a card of a certain color and she gave these cards out during the day. And there was red for you're the troublemaking kid, right? And then different colors for the others. And she discovered that it was just really one kid that had a lot of contact with a lot of people, and he needed some extra supports. And when she was able to use her experience and knowledge and give him the extra supports, the whole class settled down. But the chaos that was created was really overwhelming. And so what I want to say about geospatial data is that we actually have data, that social identity data, which is sort of the cover-all word for age, race, demographics, education levels, whether you rent, whether you own a car, how far it is to get to a court, it can also be in there. So we have all that social identity data along with technological capacity. So we have a lot of data now on digital access, digital resource, the cost burden. So even if where you live is wired for a speed high enough to do what you're asking people to do. The cost burden might be so high that we can see that the people who live there, no way, no how, they're never going to afford that. By looking at the intersection of the data we have, we can very intentionally see, and when we overlap that with who your customers are, who the litigants are, where they're coming from, you can very intentionally see, just like that teacher was able to see, it's one kid who needs extra support. You very intentionally can see who is going to need extra support to be able to get through the system efficiently. And then you can find, now we have the community partners that can help give that extra support. That shouldn't be on your shoulders, right? You can't do everything. You can do your job. But now we have the data that can drive that kind of decision and partner building and making. And I think that is one of the really exciting developments. And I urge everyone to learn more about it and call me if you have questions.
Thank you. All right, to you, Edwin.
Well, I'd like to sort of piggybacking on the things that have happened, the technological opportunities that we've had, remote hearings and versus in-person hearings and other transactional business that courts have historically been engaged in. You know, again, we have to remember that there are some people that lack access to those technologies. And so in some way, shape, or form, those of us who run and operate courts must keep that in mind, that not everyone has high-speed internet. All of you here, and maybe for the people who are watching this live stream, you know that if you're on Microsoft Teams or Zoom or WebEx or whatever, that it's a significant drag on bandwidth for your internet. And even for some of us that have high-speed internet available to us in our residences, sometimes it's not as good as it should be. And you have to keep in mind those people who are in areas that aren't serviced by some of those technologies in a way that makes sense for those residents, and then certainly at a cost that they can afford. You look at the other opportunities where, you know, what's transformational is even having the dialogue. Things that haven't necessarily occurred before. Marcus talked about us having to pay attention to wanting to step back into the old way of doing business. That's a problem if that occurs. Certainly there are instances where the old way is the better way to do things, but I think all of us have figured out that some of the newer ways of doing things are even better. And as a matter of fact, some of those things aren't new. 20 years ago in Alaska, there are things that have been done out of necessity that, quite frankly, some of us have just skipped out on. And I'll say this, when you're looking to make transformational change to any system, you certainly have to have the buy-in. You need the buy-in, you need the people who are the ultimate decision makers to agree to allow some things to occur. You also have to agree to allow for some failures. That is very scary to some people, especially for our top-level judicial branch leaders, especially our judges, who feel as though if something doesn't go right, it might be a personal indictment on them as individuals. Now, I'll say this. If you're a court administrator, deputy court administrator, court manager, court clerk, supervisor, in my opinion, it is your responsibility, not the judges, to figure out the things that need to happen and how they should work. I'll speak frankly with you. For years, I would hear court administrators say, well, you know, whatever my judges tell me to do, that's not good enough. And if that's the position you take, you are in the wrong job. And there are enough people who know me that I'm gonna be straight up with you. And if you're watching this from home or your office, I'm talking to you too. That's an insufficient response to place all of the expectation for transformation on at the feet of the judges who have their other responsibilities that they're concerned about to ensure that legal precedence is met, that they're following the law, that a number of different things that are happening. But those of you who are here in attendance, you are administrators, you are the operators. It is your responsibility to offer the judges I'm losing my train of thought, but offer the judges some opportunities to where they can advance the causes, because otherwise it's not going to happen. It is also your responsibility to some degree, advise our judges and our other judicial leaders on how and why this makes sense to do things differently. Because it's very easy for them to want to sit back to what is comfortable for them, what they're used to controlling, how they're used to moving things around. We have to make the necessary changes so that all people will be served equitably. And I'm sure we'll touch on that a little bit more in a few minutes.
Great. Thank you. Thank you for pushing us, pushing everybody in this room. Right, Mark?
And those on the virtual as well, right?
Yeah, right.
Thanks, Edwin. So how do we consolidate these gains? And there's not one solution, certainly, but I know for Arizona, we did look really closely at the Minnesota model, where they identified the types of hearings that would be held in person and also remotely. And it was a very kind of an analytical approach, and we like that. We had Jeff actually come out and meet with us a couple times on that. But we found that digital divide that Edwin touched on, it's not only true for the consumers, it's true for courts, right? We have some courts that are state of the art, and then right down the road, they don't have that bandwidth. They don't have the staffing maybe that's necessary and so on. So in your materials, I think maybe that top middle report, you'll find some work from Arizona's Plan B committee, and they adopted, or recommended, I should say, standards, presumptive standards for each hearing case type, but also hearing type. And it's quite a detailed chart, if you will. And but then they said that these standards should be reviewed by each local court, okay? And they could be adapted to kind of fit the staffing and the technology resources of that court. And it was quite a little process over the summer, but I was really grateful to see about 180, well, actually all the courts, 180 courts did develop their plans. We reviewed those, and the Chief Justice signed off, and we're now kind of in the evaluation stage to say, gosh, do we need more changes? But to me, that was sort of a governance model to say we want some local flexibility, but yet from a consumer standpoint, we want the litigants to know ahead of time what should they expect in the way of their court process and whatnot. So that served us well. A couple other things you might think about for your office is we did use a heavy amount of ARPA funding, okay? If you folks tapped into that federal money, American Rescue Act, and we're using that with bandwidth, equipment, the Zoom license fees, and now just recently have lined up what we call tech bailiffs, technology bailiffs that would be available in each of the counties to help with all that integration of equipment and kind of the daily operations. And so, but I think these kind of measures can kind of help us to maintain the gains that and kind of leverage these as we move into the future.
Oh, thank you. Yes, Catherine.
Could I just add a footnote?
Yes.
I think the point that Edwin was making about allow for failure, right? Like if we are going to change systems that have been in place for hundreds of years, it's hard, right? And we have to contain the risk, right? We're all pretty risk-averse people in this room. I don't know that anybody here could claim not to be. That's why we're in the business we're in. And so I think the mechanisms we do that, one thing we learned about the pandemic is, you know what, we can write an administrative order for anything, right? Like you can write a temporary administrative order in the interests of justice for anything, which means you can write orders that create pilots for things. You get the judges that are champions where you can have that buy-in. And you know what, the public are allies with you in this. You know, when somebody's at the counter and you're sorting out where you're going to put their case, you could say, you know, we have this new thing we're trying out because we think, you know, this kind of whatever the procedure is might be a little faster, might be a little more efficient. It's not our standard thing. Are you willing to, you know, here's a handout on it. Are you willing if I put your case in that? You know what? The public's going to say yes. Oh, that's going to be faster. That's going to be more efficient. But they'll also understand that you're learning as they're learning. They are not your enemy in trying to become better. And that, that was something that took me a while to learn. I was very defensive about the public, but we can really co-opt them into being our ally and help us do it better and allow for the failures. And they will be like, okay, that didn't work so great. But they'll be like, but we learned a couple of things. You could do the debrief. The judge will learn. And then the judges who got left out of that experiment, because I ran a few of these in Alaska, I'm going to tell you they're jealous. Jealous as all get out, and they want in, and then they want everything to be done that way. So it's a great way to build, and learn at the same time. So sorry, I think it's such a great idea to let us fail in a safe way, or expose ourselves to failure in a safe way.
Yeah, absolutely. And I would say those leaders that are willing to fail are also the ones that shape the path forward for everybody else. So Marcus talked about Arizona. I know in Minnesota there has also been done a ton of work around remote hearings and setting expectations for what case types and when are the appropriate times for a hearing virtually. And Colorado, I know, is right on the cusp of this. And at first, I think that was challenging to think about for Colorado, telling the judges that you need to be using virtual hearings and continue to use them in these types of cases. But what wins people over is looking to other states. Well, now you have Minnesota's doing it. Now you have Arizona. And when you have those examples of the leaders who are willing to fail, it brings along others who might be those second dancers on the hill, if you've ever seen that video. It's easier to follow and join in when somebody else is already dancing on the hill and being crazy. So we need those people who are willing to take that risk. All right, well, I'm going to turn now to public trust and confidence. We talked a little bit at the very beginning about declining public trust and confidence, and we see that's one of the major challenges facing our justice system right now. So how do we grow public trust and confidence in the system along the way as we're engaging people around the table and having these failures? How do we also engage the public? So I'm going to switch it up. I'm going to start with you, Edwin.
No, I think it goes to that public engagement and community engagement. I think you do it as often as you can. In my experience, many times, many of our courts, we may become engaged in those sort of community reach out efforts once every blue moon. The problem with that is that when there's a lack of familiarity with the system and a lack of familiarity with the people who work in and operate the system, there's a natural distrust there because I don't know you. It's like working somewhere and you never get an opportunity to meet the person upstairs in the corner office. There's this unfortunate but natural distrust for whatever it is that person in the corner office is trying to do or trying to achieve. And so you have to make efforts to more frequently engage with people. Because in my experience, again, is if people realize that you're at least trying, that you are listening to what their concerns are, you're making efforts to address those concerns wherever you reasonably can, they'll be more willing to speak highly of you and what you're trying to do. And when neighbor speaks to neighbor, that's better than an email or some email blast or some other communication from the court. They're going to trust what other people who they trust have to say about you. And we need to piggyback on that trust. I think that let me back up. Social media is sort of like, it's like an addiction for many people. And you match social media with traditional media, and we've got our own pandemic of misinformation. There's lots of information that gets spewed out, especially as it relates to the justice system overall, that the courts either do not or cannot respond to. And when you are quiet on a subject, or if you do not respond, it comes across to some people as though you're complicit, that it must be true if the judge didn't rebut whatever was said about him or her or they. And so while that is an uncomfortable position to be in, it's one that is here and will not go away and will only get worse as information travels around the country and around the globe. As people are able to see things visually, and I'll use an example. Obviously, we're here in Minneapolis, the George Floyd murder. People got to see that. Now, the response generally from judges is that, well, we're not the police and we didn't kill anybody. True. However, when it's time for these cases to reach our doors, the courthouses, the general public sees us all the same. We're the courts. Yeah, we weren't police officers or sheriff's deputies or constables or whoever, and we didn't do a misdeed, but they see us as partners, which we are in the justice system, especially the criminal justice system. And so knowing that, we have to be more proactive in how we rewrite the narrative, as opposed to always sitting back and letting other people write the narrative for us. It's like politics. If you were a candidate on one side of the aisle, you don't want candidates on the other side of the aisle writing the narrative for you and your constituents. The general public, people at large, for us in courts, those are our constituents, whether they vote or not, whether they voluntarily come into the system or not. We have to figure out ways to engage with them. And again, it's not enough to let things happen or run their course. And I've heard all these different words over the past few years. It's not sufficient, because as people enter the systems, utilize our systems, whether they want to or not, they are developing their own mental report card of what our system is and what it means to be a part of that system. And so we've got to take the necessary steps to ensure that we get A's, not C's and D's. Because as you look at the 2022 survey that was done, the confidence, public trust and confidence level is going down. And I think we can remedy that if we choose to do it.
Wonderful. Thank you. Marcus.
I think we can take actually a page from the e-commerce or the private business sector when it comes to the public engagement. I mean, think about it. Every time we do kind of a business transaction, there's that quick survey. They want that feedback. They're hungry, right? And those analytics. And so I'm still really big on core tools. Measure one, what was it, the fairness and access? And I still recall in the little notes, somebody said the map to the Google map to the courthouse is wrong. And that person was right, okay? It was a brand new building, it had terrible signage, and so, but that's years ago. I think we also can use those surveys to help shape policy. And so on this remote hearing issue, we were starting to get some resistance, I would say, from the bench and other areas to say, you know, don't push too hard on this and don't do any kind of mandatory policies. So we did it. We paid for a survey of the public, and I like it because it was not just opinion. What do you think about this? We asked a couple other kind of probing questions first. Have you had experience with webinars or other online services, let's say medical appointments and whatnot? And it was amazing to see 60-70% said yes during the pandemic. Did you have any interruptions in service? Very rarely. If you did, could you resume the business, the communications? Yes. Okay. And then finally, about the fifth or sixth question, we said, now, what do you think about this for court hearings? And then we did a little deeper dive by case type, if you will. So those findings were really favorable, and it was terrific to bring that to our Supreme Court and to our bench bar committees and whatnot to say there's that kind of support. And other stakeholders there would include the bar. We did a separate survey there with the Arizona State Bar, and then the bench itself and staff. So think about those kind of measures and how maybe that could help shape policy. I hope you're all doing like juror exit questionnaires, that kind of thing. It's a real quick, and it can even be a sample. It doesn't have to be every week, every day, but I think that kind of information can really be helpful to get a sense about the public, kind of the customer experience.
Right, thank you.
So two things. The first has to do with the opportunity we have to build relationships every single time somebody walks into our clerk's office. When I first started at the Alaska court system, it was 2001. Stephanie Cole was the administrator. Some of you may remember her. And she had this initiative where she had laminated little pieces of paper that said customer service and put them all over the clerk's office. Now, I'm gonna tell frankly, and who knows, Stephanie might be watching. There's a good outcome to this. At first, people were just kind of laughing at it and making fun of it, right? Like, we're the clerk's office. What are the customer service? But as time went on, I started to see how it changed the mindset of everybody who worked in the office and the people who came to the counter. So when they saw this little laminated thing that said customer service, it immediately told them they were in a different place, even if the clerk wasn't on board yet, right? But they felt, so they came with a little more generosity of spirit. And so I think thinking about our interactions every time we interact with a pro se litigant, whether it's at the clerk's office or in a courtroom or on the telephone, that's an opportunity for two things. One, it's this building of public trust and confidence, because guess what? That's the reputation of the court they're going to bring home. And I knew our self-help center had made it when one of the exit questions we asked people was, how did you hear about us? And the person on the phone said, oh, I was camping with some friends and I was telling them I was breaking up with my wife and blah, blah, blah. And he's like, oh, you gotta call Judy at the self-help center. She's gonna set you up. She's gonna help you. She's really nice. That being referred by a friend, that we were a trusted place to go and get some help, that improved the public trust and confidence in that system. The second piece is for working on automated forms or just forms and instructions generally. There's a lot of talk about user testing. Every time you talk to a pro se litigant, that's a user testing session, right? You all and your staff are the experts of knowing that question 5 never works, right? People always get it wrong. So that's the thing then to elevate to whoever can edit your forms. I'm thinking about yesterday, John Grecian and Alan Carlson, when Alan read off that list of names of things. Do you remember like all those actions? I mean, it was crazy, right? I think we should all know we should change the names of those. But we have to do that at a local level. So that's one way for, I think, public trust and confidence that we really have this amazing opportunity, not only to improve our services, the public sees that we're responsive and we build relationships. The second way, and this is sort of my dream thing, is we get to do the blue sky piece, is I think increasingly, I mean, the work that you all do of community engagement is amazing, but it's a big lift, right? Like it's a big exercise. We're gonna have some kind of community listening session or something like that. If we could be, as we're a branch of government, more like, think about your local hospitals or school districts that have standing bodies that are citizen advisory bodies. And where civic-minded members of the community can be permanently involved in some kind of rotating way. There is an ethical and appropriate way for the community to bring concerns and the court to respond. I think that you can't march up to the Chief Justice's office and be like, hey, this is all messed up, right? Like we have no pathways for people to even talk to us. And the appropriate way to talk to us now would be to send us a letter, right? Literally, that would be the appropriate way that wouldn't get people's hackles up. An email would get everybody's hackles up, right? You never email the court unless you're filing a document. So I think thinking about, can we, like these other, like as has happened in the executive branch, create, or in the private sector, or with hospitals, I mean, these sectors that have created a permanent, trusted way for the community and the institution to talk to one another. And when a crisis occurs, to be able to say how the institution can be responsive, what it can and can't do, and so on and so forth. So that's my dream hope, that one day we can build accountability and trust and confidence with our communities, but we're going to have to give them the institution to do that, right? They can't do it on their own. Like nobody here is going to be responsive to like a mass of people banging on the door, right? And we shouldn't be. It needs to be done in an intentional way with boundaries and etiquette and all the things that we're used to.
I think that goes directly to the research that we have that goes to how people are experiencing their justice problems, right? And they don't always know that they're a legal problem, and they don't always know where to go. And so if you've been embedded as a court system into the community, and you have those trusted partners, and you have relationships, and you have opportunity for give and take with members of the community, it's more likely that they will see the court as an opportunity for a solution. There's a pathway to the court, even if it's not just filing. And we can, going to civil filings, potentially gain back that market share, have people come to the courts to see it as a place for solutions.
Yeah, I thought that was really interesting yesterday with no matter how high the rate was for small claims filings, like the limit, the numbers just keep dropping because the public just doesn't know. And so how can we create the muscle?
Absolutely. All right. Well, anything else critical you would like to share that we haven't covered? Blue sky thinking, innovative ways for us to tackle these huge problems. What are your dream solutions?
Well, I have one, more than one, but I'll stick with one for the sake of time. This is a solution that I think is important for courts to consider utilizing. It's a tool. I think Marcus mentioned court tools earlier. We have a new tool coming out called the Racial Justice Organizational Assessment Tool. And what that is, it's like the compass. Frequently, if there are issues that have come up, that are uncomfortable within a court system, we go with the attack the squeaky wheel, right? So the squeaky wheel's going off, something's obviously occurred, and we devote our time and our resources to fixing that squeaky wheel. Sometimes that's not the best use of time and resources. Maybe there are other matters that need to be addressed that are below the surface or that people haven't felt comfortable talking about publicly. And so we've created this tool that we believe will be public on March the 1st, called the Racial Justice Organizational Assessment Tool. Thank you, support for State Justice Institute for the creation of that tool. And we think it's important for courts to consider using that tool to assess themselves. So you can privately see if there are issues pertaining to diversity, equity, and inclusion that need to be addressed within your respective court system. It's a private tool. It's not something where the data is shared with the National Center for State Courts or anybody else. But the number one thing I was asked to create upon my beginning my tenure at the National Center was to come up with a tool that courts could utilize to help them assess themselves. And this is the compass that courts will be able to use for free. It doesn't cost anything. I also think, and I want to say this, I think that it's important, just like we have this training, just like people come here for professional development, I think you have to assess yourself and your processes in an ongoing way. You need to, set benchmarks and goals for yourself, as opposed to just business as usual, and as opposed to just waiting for someone to complain, whether they're complaining about some outcome pertaining to race or ethnicity or gender or personal identity, or if it's outcome pertaining to the technological advancements that seemingly are available to some people and not to everyone else. We've got to continuously assess ourselves the same way that the private sector does. No organization where either hundreds of thousands of dollars or in some of our systems, millions of dollars are spent primarily of taxpayer funds. No organization would fail to assess themselves to see where they can make necessary adjustments for improvement. We all have room to improve. And I think that if we take the approach that this isn't an attack on us or on our judges, but an opportunity to tweak things from time to time, it becomes less scary when you view it as such. And I'll last again, and I know I'm still talking. Isles, there's this I believe it was a study that was done, and I don't see the cowboy hat, I don't see John Grecian, but the 18
18 ways.
18 ways. It's like, I can't believe that courts haven't been taking that document and following it to the letter. Or years later. I mean, I don't know how old it is. It's not that old, of course, but because John is so young. But it's something that there are advancements that really aren't advancements anymore, that have long been around. And quite frankly, now's an opportunity to continue to utilize those advancements that we were forced to use during the pandemic, but to take some things off the shelf that have already been available that maybe we haven't been utilizing. And that, I think when you do all of those things together, because it's not you can piecemeal things, but it's really a collaborative effort from people, technologies, systems, and such. When you do all of those things together, you build more trust in the community, and people feel a bit more comfortable in utilizing our systems and coming into our courthouses and into these legal spaces that for them can be quite scary.
Well, I appreciate the shout out for 18 Ways, and I will
That's right.
agree. It's actually one of ISLE's most popular publications, and I encourage, if you have not read it, it's only 18 ways for you to take a look at improving your courts and improving navigation for people. And I would also say what sparks what you said, what that sparks for me is that to be transformational, you don't have to come up with an idea that has never been thought of before. That can be daunting, that can be overwhelming. How do I think of the way to manage this court that nobody has ever thought of? You actually just need to scan the landscape. There's so many great ideas. There are so many ways to take something that's already been done and think about it in a new and different way in your court, with your situation, with your needs. And that can be transformational. So I think it's a little bit easier than, we think about blue sky thinking, but it's actually possible to just look at some of the things that came out before the pandemic. I will also give a shout out for the Civil Justice Initiative that ISLES and the National Center partnered in. There's so many great things in that civil justice reform work that if you look at them post-pandemic in a new light, they're all the more relevant. And I think we can really pull from the work that has been done for so many years, rather than feeling like you have to reinvent the world. So Marcus, your thoughts?
Well, just real briefly, and I think Brittany, you said it so well, it does seem overwhelming, everything we've talked about today, to me. But I think as administrators, as leaders, we can add the dimension of time, okay? And I love when Catherine was talking about a small pilot project that might cascade across the whole system. Or if you have a regional court, that's a great place to try something on a small scale, test it, refine it at a kind of a relatively low risk. So do think about that. And I don't think it has to be a 25-page strategic plan, okay? It can be a very simple chart up on a whiteboard that you would share with your staff and kind of get the endorsement from the judges or the bench and then kind of move forward. I think that gives you a little bit of protection, a little space, and it also says that we're not going to do everything the first week we get back to work. So do think about that. Approach has really served me well over the years.
Yeah, I guess I just want to close saying, in addition to, there are so many great examples and resources, we actually have now, and I think the study that Brittany started with, the Pathway study, is a great example of some really hard research coming out in the field that can back up what you know. Right? Like you actually know all this stuff working on the front lines. Like you can see the problems, but in order to persuade the leadership or to persuade funders or the legislature or whoever it is, we need the research. And one of the most exciting things I think that's going on now is a lot of the investment that the Pew Charitable Trusts has made in projects around the country that is really looking at how to help us with data, how to help us with forms, is going to be research that's going to be really impactful. And through your communications channels, as that comes out, I know you have so much to read, but maybe you can find somebody in your location who can be like in charge of reading the research to tell you what might apply to your situation. And that might even be a college intern, right, who's just interested in learning how the courts work, but they read all the time, so give them something more to read and write a paper on. But one of the things I think we're about to see come out pretty soon for one of these Pew-funded projects is out of Indiana. A professor there, Victor Quintanilla, is doing really extraordinary work in partnership with his court and the Access to Justice leadership. But one of the really, and he's studying digital court appearances and what the outcomes, how they may or may not differ between pro se and represented. So sort of like the regular stuff we always look at. But one of the really unique things we're going to see coming out of Victor's research is something about psychological safety. He also has a doctorate, he's a lawyer, but also has a doctorate in psychology, and has really looked at the issues of psychological safety and the impact of how a litigant performs within the court. And so when we think about, as somebody who's very interested, myself is interested in pro se issues, it's all about how to figure out how to get the relevant evidence in front of the judge so the judge can make a decision on the merits. That's the mantra John Grisham taught me 20 years ago. I repeat it still. When somebody is not psychologically safe, what do? We clam down, right? We completely shut down. We can't talk, we can't share, we can't give the information necessary. And that's why this is just important on its own for people. But secondly, for the DEIB initiatives that we have, that everybody in our community feels safe when they come in and they're dealing with the administrative parts of this process, and that, and we have the people, so many people doing great work on procedural justice, but this is something more than procedural justice. And so I hope that we start thinking about that and also can analogize it to our own experience of psychological safety. Like when we go to the doctor's office, right? And you're gonna get a scary, you got some tests back that are wonky. You can't hear anything the doctor says. And if the doctor gave you all that information and said, okay, now decide right this second what you're gonna do, who knows what's gonna happen. So that's why we also need to create those processes, and this is where you all come in, where there's a gap between learning and decision making. And that can support that psychological safety. So I think these are like really important new kind of ways of looking how to do our business well. So.
Wonderful. All right, well, I will admit we have a little bit of time for questions, although I don't know that we have a mic to send around, but I can hand off my mic if there's a question, if someone could help me run it. Yes, thank you. Well, we have people who are listening virtually, so I'm going to send this your way.
Thank you, Rick.
Thank you. My name's Howard Gentry. I'm criminal court clerk in Nashville, Tennessee. When I first looked at your numbers on the screen, I went, wow. And I come to NACM for answers, and NACM has given me answers for almost a decade. And today, when I saw those numbers, I'm saying, wow, we're getting ready to discuss some serious stuff. We got a bunch of good information, and I promise you, I jotted down a lot of notes, but we didn't get to that serious stuff until the end. And I would suggest that the next time we come together, we make the results or information from that study prominent. And discuss it in detail with possible solutions. Right now, we find ourselves in the courts kind of dealing with people like the King's Men. Humpty Dumpty already fell off the wall, and we're picking up the pieces and trying to make justice out of injustice that's already occurred. And that is things we need to talk about. We might not have the solutions, but that makes our job a lot harder. So I would like to talk about the fact that when you come to the public trust, Based on those numbers, if I'm a certain hue and I have a certain economic standard, status, I can trust that the system's going to be pretty good to me. If I'm a certain hue and I'm poor, I can trust that I'm not going to be getting the service that I need. So those kinds of things I think we need to discuss. And quickly on one HR side, a lot of us in this room have been promoted because of our skills, our court skills, but we really haven't been trained to be managers. But we've made do until COVID. Now we have problems about how do we deal with employees that don't want to come to work? How do we deal with the mental stress from COVID and what have you? We haven't truly been trained in those areas. In Nashville, in my office, I only have 91 employees, but I created an HR department with a real HR person because I needed her in this time. And I'm also sending my managers and my employees to management training to help them through these times, because these times are different. And I think those of us who are skilled, who do not have the management skills, need to get that to allow us to move forward in these new times that we have. So thank you.
Thank you. Thank you.
Don't everybody see all at once.
Yeah. Anybody else? Go ahead, please.
Probably have time for one more question or comment.
And Edwin likes really complex questions.
I'll make a comment since we don't have any questions. Don't be afraid you don't have to go it alone with anything that's been discussed up here today. There's somebody somewhere who is willing to help you, to help provide the private guidance, the non-judgmental guidance and support that you might need, or you may ultimately need at some point if you decide to embark down a particular path, whether your considerations for transformative justice have to do with the technological revolution, have to do with DEI and belonging and racial justice and what other outcomes that you need, whether it's jury composition and jury services, or something as simple as how you treat people when they come to the counter in one of your respective offices. There's someone here that can help you and guide you through. And it's important for you to know that, because often we come together and I think sometimes people go back and they still feel as though they don't have anyone to talk to when it's time to act. And so therefore it causes you to become paralyzed and then you don't act. I don't want you to do that. Just as a NACM member myself, I've been a member of this organization for 16 years, excuse me. And so because of that, these are the very people that you look around and see who can help you. Now, there are a lot of people here from Minnesota, so if you want to call someone from a different state, we'll be sure to get names and email addresses and phone numbers to you. But I'm glad you're here to hear what we all have to say, so thank you, and thank you for inviting me.
Yes, thank you all. And I will say, we're talking about weighty issues, right? We're talking about justice, but we're also talking about injustice, and that, I just want to second that these are critical issues that we have to grapple with, we have to tackle, but we can do it together. We can look at research, we can work as a community. And I actually had a quote here to end the session, which I just saw from our partner Hill, the Hague Institute for Innovation of Law, that they posted on Twitter just a couple hours ago. And I thought it was so poignant. It says, "It takes a village to raise a child, and it takes an ecosystem to scale an innovation." And we have to work together to scale innovation. We have to work together to solve these problems of both justice and injustice. And it's wonderful to be here as part of this community and this ecosystem. And I appreciate our panelists and all of you and all the work you're doing on a daily basis to address these issues. So thank you.
Thank you.